Thank you everybody for coming. I'm really excited to present this webinar today and this topic. This is going to be a really good one. Hopefully it'll be informative and helpful for everybody to hear some updates on laws to, stay ahead of things for 2025. And we'll have some Q&A at the end. So in the interest of time, I do have a lot to cover today, and I know that people are still coming in, but we'll go over some of the housekeeping. First of all, I've been working on the SoCal Realty Law magic statement that I use in networking and whenever I present what we do. So this one's new. I used to say we protect real estate investors and real estate professionals, but I think the new one is going to be here at SoCal Realty Law. We help property owners protect their investments, maximize value, and avoid liability. We do this by helping get rid of problem tenants, providing good real estate contracts, and litigating issues that are important to property owners. So there you have it. Hopefully you like that one. I'm going to keep working on it. All right, and then as many of you know, since April 2020, we've been showing up just about every month for Landlords, live and in person, to present these webinars and keep everyone up to date on new laws, changing laws, remind you of laws that have recently changed. We were so busy in October that I didn't have time for the webinar, so I hope you saw our No on Prop 33 social media video, and it worked because Prop 33 didn't pass. So I will be telling you what the law is, reminding you what the law is, since it hasn't changed with regard to that subject matter of Prop 33. And then I hope to have some time for Q&A at the end. I will go through a long list of legislation that has passed. We'll review the other ballot proposals, but most of the ones that we've covered on the webinars in the past that I chose as things that were important to landlords, most of those did not pass, but we'll run through them anyway just to let you guys know what passed and what didn't. And then at the end, Q&A. So feel free to put your questions in the chat as we go. Rather than stopping to answer questions, I would like to hold those questions to the end. And then if you need to unmute just to explain the question, you'll be welcome to do that at the end. So post your questions in the chat and then I will run through them. I've made the chat private so that other people in the webinar can't see who you are and what you posted. And I may or may not choose to present every question. So if I don't present your question or I don't give you a sufficient answer, feel free to reach out to SoCal Realty Law after this. And we usually offer a free 15-minute call for any potential new matter or just to answer a question. Make sure to keep your questions general in their subject matter, or else I'll have to invite you to do a private phone call. All right, and what I'm presenting is intended to be general, non-biased information. It's not intended to be legal advice. Please don't take it as legal advice. It's not supposed to be related to any particular situation that you may have going on. I'm also not planning to get political today. There's no politics involved. I'm just reporting to you what the new laws are and trying to be as unbiased as possible. And some of you have met our new attorneys on staff. Our team is always growing. A couple months ago, Adam Stone presented the webinar with me. Adam is our transactional real estate attorney on staff. He joined us in June. We also have Jim Delaney, who is an attorney who joined us back in March, and he's handling our evictions and our litigation. So welcome to those guys. They are wonderful additions, and I hope you all have a chance to meet them and work with them because they are great to work with. Finally, on housekeeping stuff, I'm really sorry that the video and freebies from September have not gone out yet. I think the video might be posted, but the freebies I just finally got done. So Jessica will be sending those out to you. Again, it was just so busy in October that I didn't get around to them. So they'll be going out today. Hopefully And that September webinar was about relocation assistance, buyout agreements, and cash for keys. It was very well received and people really liked that one. So if you didn't see that one, please view the video because I also thought that it was a really good subject. All right, so with that said, let's start today's webinar. Our subject today is landlords need to know, looking ahead to 2025. We're going to review the results of those real estate related items that were on the ballot earlier this week and go over a bunch of other new laws that are scheduled to go into effect around January 1st, 2025. Of course, we will recap all the new laws in January. Again, we're going to skip December's webinar. So in January, we'll do another new laws webinar and go into even more depth on the most important new laws for landlords. For now, these things that I'm presenting today are just things to keep an eye on, and I'll give you some pointers on how to prepare for the new year. All right, so let's start with our Prop 33. I was a little worried that Prop 33 might pass. It would have really been a boon for my business. It would have kept us really, really busy trying to keep track of new local laws. Since it didn't pass, the law stays the same, and that is very good for landlords. My earlier video that we posted on social media was to vote no on Prop 33 because Prop 33 was going to make life much more difficult for a lot of landlords. But keep in mind that Prop 33 was a repeat of something that's been on the ballot at least 2 other times in the last several years. And so we'll probably see the proposal come back. Prop 33 would have repealed the Costa-Hawkins Act, and instead Costa-Hawkins stays in place. So the law remains that the Costa-Hawkins Act protects landlords by forbidding local rent control on vacancies. So the law does allow local rent control on occupied units, and we see that in parts of LA and in San Francisco and other areas. We don't have any local rent control here in San Diego. Unless you count the city of San Diego's rent cap. I'm sorry. The state of California has a rent cap. That's a form of rent control that does apply in San Diego County. Anyway, Costa-Hawkins was passed in 1995. It only affects residential properties that were built after 1995 or in 1995 or later. And there are some exceptions to this law that are worth reviewing if you're concerned about how it might apply to you, or if you're in an area that you have those concerns. But basically, Costa-Hawkins protects landlords from vacancy decontrol, and landlords are allowed to increase the rent when they have a vacancy. They can increase the rent to fair market value. In the event that the vacancies would become rent controlled, it becomes really, really important for landlords to maintain fair market value of the rent as much as possible. So when you are allowed to increase the rent, it's important to do so in order to keep up with inflation. All right, so then we have Prop 5. Prop 5 did not pass either. Prop 5 was a law that would cause some local government financing for affordable housing. It would have lowered the voter threshold for local bond measures, and this might have made it easier for local governments to secure funding for housing, infrastructure projects, and potentially increase development opportunities and enhance property values in areas that would benefit from improved infrastructure. So it did not pass. It might have been a positive change for investors who were looking for long-term growth. So we'll keep an eye out for that one next year, see if it comes back. Then we have Prop 32, also did not pass. This was the increase to the minimum wage. It was proposing an increase from $16 per hour to $18 for workers that would have started in 2026, or depending on the size of the business, it would have been in 2025. There's already an automatic inflation adjustment that occurs whenever inflation hits 3.5%. And that did not change. The minimum wage did not change. So we'll just keep moving through these. Okay, so those are all the props that we've previously covered on our Landlords Need to Know webinars. Those were hand selected by me as the ones that were most influential to landlords. If I didn't cover one, it was just because I didn't think that it was as important for landlords, but certainly all of those propositions could potentially have an impact. So, all right, so now we'll go over the legislation that has passed during 2024. Most of these new laws go into effect January 1st, 2025, or I'll mention it if it's already in effect or if it goes into effect later than January 1. The first one is a new, it's a change to the existing law protecting victims of domestic violence. So existing law already provides that when a tenant is a victim of domestic violence or abuse, the landlord must change the locks upon a written request within 24 hours after receiving the appropriate documentation. So the existing, or the law prior to this new law still required the landlord to change the locks when they received appropriate documentation. And the new law actually expands the acceptable types of documentation. The existing law also provides that if the person who's alleged to have committed the abuse is the tenant in the same dwelling unit, then the court order excluding that person from the dwelling is necessary. So they have to, the tenant who was abused has to provide the court order to the landlord in order to change the locks. And then it provides some other types of supporting documentations that would also be acceptable. Now, the new law further clarifies this and says that the landlord is responsible for the cost of changing the locks. They can't charge that to the tenant. It extends the lock change protection to immediate family or household members that also live in that unit. It expands the acceptable supporting documentation of abuse or violence, triggering the lock change protection, and prohibits a landlord from taking any adverse action against a prospective tenant because of their use of the lock change protection. So when we have these situations in our office, oftentimes there are different things going on. There's a criminal restraining order or a criminal record where the abuser has been removed from the property that may or may not have the move out order. And then there might be a civil restraining order or a domestic restraining order. That's where we usually see that move out order. But under the new law, the tenant just has to provide evidence of the violence. They don't have to necessarily provide the court order with the move out order. And then it can include a request by other household members. And then the last part of this, which I want to stress, is that the new changes prevent a landlord from refusing to rent to a prospective tenant who has used this lock change protection maybe with a past landlord or with the same landlord, but for a different unit. So these are positive changes, and it's nice to have further clarification of this because it can be a difficult situation for the victim of the abuse. All right, so then we have a new law relating to security deposit. We have a very lengthy, wonderful, specific statute that relates to security deposits. That's our Civil Code, section 1950.5. And that statute has existed for a long time. It goes through many changes. It sets forth the law relating to the handling of a security deposit. It is basically a handbook in and of itself. If you read through the statute, it dictates what security deposits can be used for, how deductions can be made, how they are documented by landlords. It also provides how tenants can be informed about the use of their security deposit and provides tenants with legal remedies for the landlord's failure to document and inform the tenant or for any misuse of the deposit. So the new law actually provides quite a bit of new information. The most significant item is that it requires landlords to take move out, post repair, and cleaning photos after the premises are returned to the landlord. So when the tenant moves out, they return possession to the landlord. Then the landlord does all their repairs and cleaning. And as they're documenting what's been done, they have their receipts, and now they have to have photographs. The photographs have to be delivered to the tenant if any deductions are made from the security deposit. So that used to be optional. The photographs were never required by the statute, but it used to be optional that those receipts needed to be requested by the tenant afterward. And honestly, I don't think that part with the receipts, that the tenant has the right to request the receipts, I don't think that has changed. However, the statute never required photographs, and now the new changes require the landlord to provide the photographs in order to make any deductions from the security deposit. And then, so this requirement to provide the photographs of the move out and the post repair and cleaning photos, that part takes effect April 1st, 2025. So this does not take effect until April. And that's for tenancies that are terminated beginning April 1, 2025 and going forward. Now, for tenancies that begin on or after July 1st, 2025, the landlord is required to take photographs of the unit immediately before or at the inception of the tenancy. And then as of April 1st, 2025, when the landlord returns that itemized statement of deductions, if a deduction is made for repairs, cleaning, or cleaning, the landlord shall provide the photographs, including the move-in, move-out, and post-repair and cleaning photos. So after July 1, 2025, they have to provide both the move-in, the move-out, post-repair, and cleaning photos. I know it's a little bit confusing because there's this change between what has to be done after April 1 and what has to be done after July 1. If you have any specific questions, we can try to go over that during the Q&A. You still have to provide the written explanation of the cost of the allowable repairs or cleanings. And the changes allow the landlord to provide the photographs to the tenant by mail, email, computer flash drive, or a link where the tenant may view the photographs online. If the landlord fails to provide the photographs, they are not entitled to claim any of the security deposit. And if they claim any of the security deposit in bad faith, the statute still provides for up to triple damages as punitive damages for the bad faith withholding of the deposit. All right, so the next law is a new law that provides that landlords may not charge tenants for any notice of termination of tenancy. So if the landlord has to pay money to serve a notice or pays an attorney to prepare a notice, the law does not allow the landlord to charge that back to the tenant. They're also prohibited from charging tenants a fee for paying for rent or a security deposit by check. So that's, I guess, a little add-on to this new law. There are a couple add-ons to this law. So also, if the landlord charges a higher security deposit for a service member due to credit factors, a written statement must be provided explaining the reason for the higher amount of the security deposit. And then there must be a provision in the lease regarding the return of the extra security after 6 months. So just to kind of explain that a little bit differently, if the landlord chooses to charge a higher security deposit to a service member, it can only be because of credit factors, and they have to return that after 6 months. And they have to explain this to the tenant, the service member. Okay, we have another new law. This law extends the time in which tenants may respond to eviction lawsuits. Currently, when we serve an eviction lawsuit on a tenant, the tenant has somewhere between 5 days and 15 days to respond. The shortest time period being 5 days, that's if we personally serve the tenant. If we substitute serve the tenant, then they get 10 days. And if we have to serve them by an order to post, they get 15 days. And then there's another little period of time where unknown occupants may claim a right to participate in the eviction. This new law only speaks to the initial 5 days. And so beginning in January 1, 2025, instead of 5 days to respond, when we personally serve the tenants with a lawsuit, they have 10 business days to respond. The time period does not include Saturdays and Sundays, but it does include other judicial holidays. And it's a really strange ambiguity that when we do a 3-day notice to pay or a 3-day notice to quit, we're only counting weekdays that are not holidays. It excludes Saturdays, Sundays, and judicial holidays. But with the time period to respond to an eviction lawsuit, it excludes Saturdays and Sundays, but it does not exclude judicial holidays. I don't know why it has that difference, but it does. And as a little, probably a quid pro quo between the tenant advocates and the landlord advocates, the law threw in this shortening of time for tenants to file demurrer motions in an unlawful detainer court. One of the tactics that we see tenant advocates using is that in order to buy time, and I mean, I don't want to assume that it's always just to buy time. In order to represent the tenant in court, a tenant advocate may file this kind of motion which attacks the pleadings, which, you know, if the pleadings on their face are insufficient or don't support a claim to evict the tenant advocate or the tenant may file a demurrer. So if the demurrer is filed, that delays us from being able to set the case for trial. We want to move forward with the case as quickly as possible, and if there are short time limits in which the court must set these cases for trial. But if the tenant files a demurrer motion, that's going to kick out the time to set the trial by oftentimes weeks or months. And so this new addition to the statutes provides a shortened time for demurrer motions in order to prevent some of those delays. So that's a good thing for us and for our landlords. Another new law is this qualified commercial tenants law. So there's a dividing line between residential tenants and commercial tenants. Everything that I have just been talking about pretty much applies only to residential tenants, but now we're seeing that small commercial tenants may need some of these rights as well. So beginning January 1, 2025, this new law is extended for qualified commercial tenants. The qualified commercial tenant is a tenant of commercial property that meets some of the following requirements down at the bottom of the slide. Both of these requirements. Number one, the tenant is a micro enterprise, generally meaning the business has 5 or fewer employees, or they're a restaurant with fewer than 10 employees, or they're a nonprofit organization with fewer than 20 employees. And for a month-to-month periodic tenancy or shorter, the tenant has provided the landlord with a written notice that the tenant is a qualified commercial tenant and a self-attestation regarding the number of employees, or for leases that are longer than month-to-month periodic tenancies, so like a 1-year lease or a 6-month lease, the tenant provides the notice and self-attestation before or upon execution of the lease and annually thereafter. So the tenant has the burden of providing this notice to the landlord, and if they do, then the landlord has to provide the tenant with 30 or 90-day notices to increase the rent. If you recall, there's a 10% cap on any rent increase, despite whether, regardless of whether the landlord is subject to a rent cap of any kind. In a residential tenancy, even one that is exempt from a rent cap, you can't increase the rent more than 10% in a 30-day period. If an exempt landlord, an exempt residential landlord is going to increase the rent more than 10%, they have to give a 90-day notice. Until now, that did not apply at all to commercial tenants. Commercial tenants are only entitled to a 30-day notice or whatever their lease requires. And so now this additional protection applies to small commercial tenants. Also, the 30 and 60-day notice requirements to terminate tenancies for no-fault evictions now applies to these qualified commercial tenants. Prior to now, any commercial tenant was only entitled to 30 days notice unless their lease says otherwise. But with this change, a qualified commercial tenant that has been in the property for more than a year would be entitled to a 60-day notice to terminate their tenancy. And then there's a law that if the landlord communicates with the tenant in a different language, the landlord has to provide a copy of the lease agreement to the tenant in the language that they communicate in. So if the landlord negotiates the lease in Spanish with the tenant, they have to provide a Spanish lease. They can provide it in English too, but they have to provide one translated as well. And many of the form leases that we find, like the California Association of Realtors forms, you can get them in a variety of different languages if you need them. So keep that in mind if you have qualified commercial tenants. In the interest of the landlord is protected from making a mistake here because it's the tenant's obligation to notify the landlord if they are qualified. So landlords, keep an eye out for a tenant telling you that they are a qualified commercial tenant, and that should keep you safe. Another new law, we have restrictions on applicant screening fees. So this new restriction applies to all residential tenancies of more than 30 days. It excludes short-term residential tenancies, but pretty much all of our usual 30-day or more tenancies will be restricted. The new law prohibits the practice of charging an application fee to a prospective tenant unless the landlord or agent knows or should have known that a unit is available or will be available within a reasonable period of time. So you can't just keep taking applications and taking those fees if you don't actually have any units that will become available. But for larger landlords who need to, you want to have a pipeline of applications because maybe a unit could come available at any time, it does authorize a landlord to charge an application fee under limited circumstances when the landlord adopts an application screening process where all the completed applications are considered as provided in the landlord's written disclosed screening criteria in the order that the applications were received, or the landlord agrees to return the fee to any applicant who is not selected for the tenancy. So basically, the landlord has to have a policy in place in order to take these application fees if they don't necessarily know if they have a unit available. Let's see. It also requires credit reports to be provided to the applicant if the screening fee is paid. regardless of whether the applicant has requested it. So if you run a credit report, you have to provide it to the applicant if they have paid the screening fee, regardless of whether they ask for it. And the idea here is that they propose that this might lead to a more streamlined application process. However, this new law could also increase the risk of renting to unsuitable tenants because landlords might tend to have less information if they are not taking the application because they don't want to spend the money to run the credit report or do the investigation that might cost them money if they are not charging the fee. So property owners might need to develop new strategies for vetting potential residents. Okay, so for larger landlords where the landlord has more than 15 units, there's a new law that requires the residential landlords with more than 15 units to offer each tenant obligated on a lease the option of having the tenant's positive rental payment information reported to at least one nationwide consumer reporting agency. This is a really nice development, and the policy behind it is that many people who don't have a lot of credit history or may have had a bad credit history, they never get the benefit of having in their credit history that they've paid rent on time. That information does not show up on credit reports, and so it doesn't help their credit scores. So this measure attempts to solve that problem by giving those tenants the opportunity to have their positive rental payment history reported to consumer reporting agencies. And when I have a nonprofit that I work with, and one of the big issues that people have when going from maybe homelessness or having difficulty as a tenant and then getting into more permanent housing is that they might not have good or they might not have any credit history. So this is a really positive move in the state of California that's going to help a lot of people who are trying to get back on their feet. Or maybe it's young people who don't have credit history yet. All right, we've got some additions to our discrimination laws. Lately at SoCal Realty Law, we're seeing a lot of complaints by tenants against landlords that are being submitted through the California Civil Rights Department. The Civil Rights Department used to be the Department of Fair Employment and Housing. And so the Civil Rights Department is very actively pursuing a lot of these cases. And the source of many of the complaints that we're seeing in our office is discrimination. The tenants are alleging that the landlord has unlawfully discriminated. The Civil Rights Department may investigate, they offer mediation services, and if the investigation turns out to support the complaint and the landlord does not mediate and settle the matter with the tenant in advance, the Civil Rights Department may file a lawsuit on behalf of the tenant. So these additions to the discrimination laws, let's start with what California currently protects. Under the California's Unruh Act, let's see, California protects people who are within these certain classifications that are listed in the law. In particular, race, color, religion, national origin, ancestry, disability, sex, gender identity, sexual orientation, age, immigration status, source of income, marital status, familial status, and genetic information. So California has very broad protections that exceed what's provided in federal law. We protect more people than just what federal law protects under those characteristics. So the new developments go into effect January 2025. Specifically, the Unruh Act is expanded by defining the term race to include traits associated with race, including but not limited to hair texture and protective hairstyles. The UNRU Act entitles all persons to full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever. And we also have the Fair Employment and Housing Act, which protects people in housing and which also has very similar protections. But this specific changes to the UNRU Act, which is protecting people in facilities, services, and all business establishments. The other part of the discrimination laws that is changing as of January is the enforcement of discrimination. So existing law recognizes this concept of intersectionality, but now it is being codified into our statutes. Intersectionality means that this discrimination may be based on a single individual characteristic or on the basis of a combination of two or more protected characteristics. And the policy behind this addition and this codification of a concept that's always been recognized, or that has been recognized as of late, is that it now expresses the concept that different forms of inequality operate together. They exacerbate each other, and they can result in amplified forms of prejudice and harm. So this change is effective in our civil code, our government code, and our education code in California. And landlords definitely keep an eye out for potential issues relating to discrimination. Please talk to an attorney or someone who understands issues of discrimination if you aren't sure. It's very important to stay ahead of that. So those are all the items that I've chosen that have already passed. And really it's things that specifically address landlord issues. There's a lot of stuff that relates to real estate that I'm not covering. Maybe we'll do a different webinar where we'll cover some more general things relating to real estate. There are a couple of other laws that are still pending. So the mandatory pet acceptance law, which would apply to properties that have more than 15 units. It's a proposal that prohibits rental housing providers from asking about pets during the application process. So these are for larger landlords with more than 15 units. The bill aims to restrict pet deposits and fees, and this could affect how commercial property owners, like multifamily property owners, manage their multifamily residential buildings and mixed-use developments. You'd have to look carefully at those exemptions to make sure to confirm whether your property is exempt or not. And then this last one is the Federal Corporate Transparency Act. And this is relevant to any landlord who has a corporation or any property management company that is a corporation. There are some qualifications of how this act applies to those corporations. The Federal Transparency Act is a new law that went into effect this year that requires companies to register with fincen.gov. They have to disclose the ownership information and the personal information relating to ownership of the corporation. So it requires most LLCs, corporations, and other entities to register at fincen.gov/BOI. Exempt companies are banks, credit unions, accounting firms, tax exempt, and inactive entities. Unless the entity is exempt, any entity created in 2024 has 90 days to register the entity ownership information. All other entities have to register by January 1, 2024. So make sure to do that if you are an owner of a corporation. If you're not sure if this applies to you, definitely check in with an attorney who can advise you. There are some pretty hefty fines and penalties relating to this law. So that's another reason why it's important to get ahead of this. Make sure to register. California has a similar bill that's kind of proposing to do the same thing, but through the California Secretary of State. It has not passed yet. If it passes, it would require beneficial owners who own more than 25% of a corporate entity to disclose their personal information annually through the Secretary of State Statement of Information. This could impact the privacy of commercial real estate investors and change how ownership structures are formed. There are some recommendations about how you could structure your entity in order to avoid this requirement. And for LLCs, it would require the name and complete business or residence address of any manager and officers. So if there's no manager of your LLC, then all of the members of the LLC would need to be listed. Please check in with an attorney. You can check in with us. My associate Adam would do a great job of analyzing this for you if you aren't sure whether you need to register. But it's most corporate owners probably need to register, not with the Secretary of State, but with the FinCEN, the federal version of this. The state version has not passed yet. If it does pass, it would take effect in January 2026. So the bill impacts the privacy of commercial real estate. Oh, I already said that. Right. So I think that's all I have for you today. That went pretty quickly. Let me see if we've got some questions in the chat that we can answer. So regarding the new law relating to security deposits and photos, how are current tenants affected by these requirements? What if no photos were taken when the tenant moved in say in 2005? All the photos are required to be sent, or are all the photos required to be sent, or for the security deposit deductions? Okay, let me go back and revisit this. Because that's a few questions in a row, but I get it. The new law affects current existing tenancies and begins to make changes to what landlords need to do as of April 2025. So for rental units that are turned over to landlords, residential rental units that are turned over to landlords, after April 1, 2025, when the landlord does the repairs and the cleaning, they have to take photos. And if the landlord takes any deductions from the security deposit, those photos after April 1 have to be provided to the tenant. So nobody has to do anything until April 1. And April 1, any existing tenancy that is terminated and the tenant returns possession to the landlord has to process the security deposit just like they always do, 21 days, to provide an accounting and a payment of the remaining balance of the deposit. And if the landlord makes any deductions, they have to provide photographs relating to those deductions, photographs of the conditions that were repaired. Then for tenancies that are created July 1 and thereafter, the landlord has to take photographs before the tenant moves in to document the condition of the property before the tenant moves in. And let's see, provide those photographs. They have to take the photographs before the tenant moves in. They would have to provide the photographs, including the move-in and move-out and post-repair and cleaning photos after July 1, 2025. So for tenancies that are terminated after July 1, you need both. So let me say it differently. For tenancies that are created after July 1 and terminated after July 1, you need move-in and move-out photos. So for tenancies that begin on or after July 1, the landlord is required to take photographs of the unit immediately before or at the inception of the tenancy. And then for all of those tenancies, you'll have the move-in and move-out and post-repair and cleaning photos. Hopefully that helps to clarify. It is definitely confusing. And as far as the final question, are all the photographs required to be sent or just photos relating to the security deposit deductions? It's my understanding that you only need to include the ones relating to the deductions. Next question, can you increase a security deposit to someone who's not in the military if their credit is not great? We have a new security deposit restriction that went into effect earlier this year. There are some exemptions to that restriction. One of those exemptions is that for military, the deposits, you can only charge 1 month of rent to a military service member. But this new law is indicating that you can increase that security deposit based on credit. The question is, can you do that to somebody who's not in the military if their credit is not great? So if you're exempt from, not exempt, but if you fall under the exception to the new security deposit rule, then you may charge up to 2 months of rent as a security deposit. It is my understanding that you cannot increase that from the 2 months just based on credit. And then the next one is there a maximum on what can be charged for an application fee? I believe as far as the application fee, you're charging back what you actually incurred. So if you charge a fee, you can't profit, you can't mark it up. So as far as the maximum, what can be charged? No, there's no maximum, but you're not allowed to charge more than what you actually paid. Can you report negative payment history? For a tenant, yes. I mean, if as with any debt, if somebody owes money and you have the ability to report that to a credit agency, it's my understanding that you can report that. The new law is just addressing a need for people to have some reporting of their positive payment history. And, you know, it doesn't really speak to reporting negative payment history, but it's my understanding that yes, you can report that as a debt. Okay, so next question regarding 30 and 90-day notices to increase rent. In what situation is a 90-day notice to increase required? So regardless of whether a rent cap applies, you know, rent caps are a whole other analysis. If a rent cap applies, you're limited. The current rent cap in California varies from area by area. In San Diego County, the rent cap for non-exempt rental units is 8.6%. But for exempt tenancies, so these are tenancies where the landlord may be exempt and has claimed the exemption by providing the tenant notice of exemption, you can increase the rent at any time. You can go beyond the California rent cap. But if your rent increase is going to be more than 10%, you have to give 90 days notice. So you can give 30 days notice for an increase up to 10% of the existing rent. And you can do that up to twice a year, but you can only collectively do 10% a year up to 2 times a year. If you're going to increase the rent more than 10%, you have to give a 90-day notice. So you can give 2 30 days notice and stay within 10%, or you can give a 90-day notice and you can exceed 10%. For non-exempt properties, it's a whole different analysis, and you need to be very careful to stay within the rent cap. And that's the cumulative increase per year can only be in San Diego County 8.6%. You can divide that and do 2 rent increases a year, totaling no more than 8.6%. Confusing? Yeah, I understand. It's confusing. Give us a call, come on in and let us know if you have questions about that. Here, I'll take down I'll keep answering some questions, but you don't need to keep looking at the slides. All right, our pre and post picks for the dispositions. Yeah, April 1st, you have to take post move out pictures and provide them to the tenant. After July 1st, new tenants get pre-move-in photos and post move out photos. With regard to the more than 15 units for positive credit reporting, is that for an individual building or for combined number of apartments? Good question. Let's see. I think it's total. Like if you have more than 15 units total, it's not all, they don't all have to be in the same building. Let me just see if I have that language available though. Let's do credit reporting. Sorry, I'm looking at my resources here. So I believe it's cumulative, but can I find it? I know it's in here somewhere. Ah, here. So it exempts small non-corporate landlords. Exempts any landlord of a residential rental building that contains 15 or fewer dwelling units, unless that landlord owns more than one residential rental building and is either a real estate investment trust, a corporation, or a limited liability company with at least one member corporation. Okay, that's confusing. So it exempts any landlord of a residential rental building that contains 15 or fewer dwelling units. So that's a building, unless that same landlord has more than one residential rental building and is a corporate entity with at least one member corporation. Yeah. So it does look like it has something to do with how large the building is, and we would probably just want to analyze that on a case-by-case basis. But it sounds like it only really applies to large corporate landlords. So, or it's only intended to apply to large corporate landlords, and it's intended to exempt small non-corporate landlords. Can you report a money judgment obtained in the past? Yeah, judgments should be, sorry, I'm blurry. Let me fix this. Judgments should be recorded with the county as an abstract of judgment. And that is typically how most judgments get picked up by the credit reporting agencies. So if you have a relationship with a credit reporting agency, or you have a collection agency that does it for you, then yes, that can be reported. Judgments are good for 10 years. They can be renewed for another 10 years. Okay. There's another follow-up question, but I think that'll have to be handled separately. So feel free to, the person who asked the question about photos and security deposits and your follow-up question, please feel free to give us a call, and I'll offer you a free 15-minute call. On a single-family residence with a long-term tenant, if you give 90 days, can you bring it up to market rent? That depends. I would have to review the lease and confirm that the exemption from the California Tenant Protection Act has been claimed, as well as exemption from any other restrictions. So, you know, typically if you're exempt from any rent caps, yes, you can bring that rent up to fair market value by giving a 90-day notice. There are some other restrictions that may apply, so we still typically want to look at it on a case-by-case basis. And then does the BOI with FinCEN only apply to LLC and corporations, and it does not apply to a sole proprietor company? I'm not sure what you mean by sole proprietor company. You're either an incorporated entity, an S Corp or an LLC, or if you're a sole proprietor, I might interpret that to mean you hold your property in your own individual name or in your family trust. So if you hold property in your individual name, or you do business in your individual name, or your property's in your trust, or maybe you have a DBA that's just registered to your individual name, then you would not have to register with FinCEN. But any kind of incorporated entity, you would need to confirm whether you have to register or not. Most smaller entities will have to register. All right, I think that's all our questions for today. Thanks for hanging in there.